Well, welcome to another Free to Be Church video. It's great to be putting something together and sending out to you just before Christmas. We hope you're having a blessed holiday coming up. It's wonderful to be able to sit down and have a chat today with Chris and Alex. Chris and Alex are the lawyers who are going to be representing our case. So it's going to be wonderful to introduce them to you and get to hear some of their thoughts on the case that's coming up and be able to patch in some of those details that us pastors haven't been able to give to you. So Chris and Alex, why don't you just introduce yourself?
Sure, thanks, Logan. So my name's Chris Morrison. I'm the chair of the partnership at Perryfield Lawyers, which is a Christchurch-based law firm. We have about 70 staff. We were originally established in 1948, and we have a reasonably sizable litigation and disputes team, and have worked over the years in lots of areas of disputes, but we have a long history of working with charities and not-for-profit organisations, and in that context have had to deal with interesting issues relating to things like the sorts of human rights questions that are coming up in the context of the current pandemic. And I should say as well, speaking for myself personally, I am a member of Grace Presbyterian Church, which is one of many churches around the country, which is impacted by the various orders being made by the present government.
Yeah, hi Logan. Alex Summerley here. I work with Chris at Perryfield in disputes, and I'm obviously looking forward to working with you guys on this case. I also attend a church out in Sumner. Like Chris, had some involvement with some of the human rights issues that get brought up in civil disputes, and the case that you guys are looking at taking on is obviously no exception in terms of raising some of those bigger public policy questions.
And of course, it's not just you two, is it? There's some people in the background supporting you as well.
Yeah, no, there's an army. So.
Awesome. Well, one of the things we stated to all of you supporters out there who've been journeying with us so far, we stated that we were going to be getting engaged in a judicial review. And that's a very specific type of case. But very recently, we've actually decided to shift from that to more to a trial, I guess would be the word. You guys can correct me. So why don't you sort of explain the logic behind why we've shifted and what's going on with that?
Yeah, so I think most of the cases that have been brought against the Crown to date in terms of challenging some of the rules around the COVID-19 related regulations have been brought using the judicial review procedure, which is more of a way of bringing a case to court that focuses on procedure rather than substance. So it looks at whether when a minister of the Crown is making a decision, in that process of making a certain decision, such as making a rule that impacts on how a church can operate during the pandemic, did the minister make a mistake along the way? Perhaps the minister took something into account that he shouldn't have, or he did take account of something that was irrelevant. Those are the sorts of procedural errors that you look at during a judicial review. And that's the sort of those are the sorts of cases that have been really litigated to date in the High Court. The sort of case that you guys are looking to tackle is more interested in having heard in a public forum the substance of some of the policies that have been made. So this is where you're looking more at whether some of the policies themselves are unlawful for reasons of being disproportionate in terms of an excessive intrusion or an unjustified intrusion into ordinary civil liberties that we enjoy on a day-to-day basis when there isn't a public crisis on.
Do you just want to maybe clarify what you mean by disproportionate?
Yeah, so probably the easiest way to think about it is we've got a whole host of rights that we're used to enjoying, and in our statute books we have the New Zealand Bill of Rights Act, which codifies and records some of those, and that's everything from the right to peaceful assembly, right against unlawful detention, and particularly for you guys, the right to manifest your religion and belief. Now, we all accept that from time to time, sort of as part of belonging to a shared and common life in New Zealand, that rights bang up against each other, and sometimes extreme situations require that there would be an intrusion to a greater or lesser extent into a right, and that's something that we accept is just part of life together. That there's no man's an island, and we can't isolate ourselves away from the impact that our decisions have on others. But at the same time, the flip side of that coin is that we still say that there are certain rights that are so valuable and key to being to living in New Zealand, that we say, well, yes, while we might tolerate a certain limit on a right given a particular context, that's not a blank check. You can't do that without limits. There has to be a sense of proportionality. So if there is a particular risk, then we might tolerate a certain intrusion into a liberty that we might expect to enjoy. But that doesn't mean that you can just wipe out a basic right without any sense of proportionality to the risk that you're trying to address.
So can you think of maybe a historical example that would sort of show that playing out in a way that would make sense to us?
One that I could give an example from another context where there are various rights under the New Zealand Bill of Rights Act in relation to, let's say, criminal activity or something like that, where there's someone who's been arrested or charged with an offence has certain rights, for example, not to be convicted of an offence where they weren't aware that it was an offence at the time they were convicted, or not to have a law retrospectively changed on them in a way that means that now they suffer a penalty for their actions that's more severe than what was in place at the time. And from time to time, the Crown may make regulations or procedural rules that actually do have the effect of changing the penalty that somebody experiences for previous actions. And so in the New Zealand Bill of Rights Act, those are recognised as being fundamental freedoms. And the courts have come down quite strongly from time to time and interpreted government actions in a way that restricts and limits as much as possible the interference with those basic presumptions that we have about the freedoms and the rights that you have to know what is and isn't legal activity within our society.
So that would be, I'm assuming this is what enables governments to do stuff like conscription?
I mean, conscription, is we haven't had in a long time in New Zealand, but those are that's obviously a concept where the state requires you to take up arms. That's a huge intrusion into, the autonomy of the person to choose their own destiny about how they govern their life. And yet we accept that in times of extreme need, that has historically been required. You can also think, wartime is a classic situation where there's a public policy objective of defending the security of the realm, which justifies the state taking what would otherwise be, in a normal context, an extreme step. So you think about, for example, if there's a war effort going on, that can have huge implications for freedom of thought and your ability to publish something that the state might consider undermines a war effort. So every crisis has its own context. And more recently, if we want to talk about, in New Zealand, you've got the Christchurch earthquakes, and the state assumed huge powers and awarded itself, Parliament gave to the executive huge powers to respond to an emergency that we wouldn't normally tolerate. And yet we accept that, provided that those powers are used proportionately to in balance to the crisis or the reasonable policy objective, then we recognise that there's a place for that. And so that brings us to then your case, which is, well, here we have a public health crisis, and we all expect that. And in fact, we'd probably all be reasonably shocked if the Crown didn't take steps to go to manage responsibly the legitimate concerns that come with that. But at the same time, that's not an excuse for again, a blank check to do whatever you want. It needs to be kept in proportion to the crisis, and it needs to be rational. And the problem with the judicial review procedure, just to come back to your question on that, is that that's a procedure that's not particularly interested in the substance of that contest. This is where you guys have gone, well, actually, we think that's a really important question of public interest that needs to be ventilated in a public forum like the High Court. Freedom of religion, and particularly the freedom to manifest your religion, that doesn't make its way into our New Zealand Bill of Rights Act just by chance. That is the consequence of centuries of wars of religion that have taken place in civilizations that we are the benefactors from. And given, this is not the equivalent of a gym membership. This is, the right to go to the gym didn't make its way into the New Zealand Bill of Rights Act for a reason. But we did say that actually there's something fundamental to being human that says that an individual should be able to manifest their religion freely. And so that, because this is such an important right and one that is appropriately recognised in the New Zealand Bill of Rights Act, it then begs the question in the current context of the COVID-19 pandemic, are the rules, and particularly the new framework that we're working under with the traffic light system, are the rules in there insofar as they affect the ability of a mosque to operate, or a church or a temple, are those restrictions proportionate, or has there been overreach?
Okay, yeah, that makes sense. So then as we think about that, and as we're planning to tease that out and wrestle through that, what are some of the sort of main areas that we're focusing upon?
Chris, you want to say that, or shall I? Sure, yeah. Well, how about I start, Alex, and then you can take over from there. But one of the key questions will be looking at what is the rationale for specific orders that have been made? What's the objective that's trying to be achieved in terms of, let's say, restrictions on gathering sizes? What's the restriction that's being put in place, and how does that compare with restrictions that have been put in place in other areas of society where the same basic objectives are in mind, but possibly a different approach has been taken to achieving those objectives? And so then bringing in expert scientific evidence to say, well, if this is the objective that you're trying to achieve, yes, what you've done can help to achieve that objective, but actually there are these 2 or 3 other ways that could have been taken to achieve the same objective, and that would not have interfered with the freedom to manifest religion in the same way. And the outcome, if we had taken those approaches rather than taking this approach, would not have been worse in terms of the public health concerns that people had. And so that if we can produce that scientific evidence to show there were other options available that had less of an impact on the freedom to manifest religion, then we can reasonably ask, given the significance of the freedom to manifest religion, why those other options weren't preferred, and in fact, were there not other options that were less intrusive in terms of their impact on churches and other religious groups?
So it will be quite an involved exercise, bringing the right experts into the picture to do a bit of a comparative exercise. Firstly, looking at at the current regime where certain activities are permitted and certain activities are regulated, and each of which will have a certain risk profile really attached to them, and seeing first whether that stacks up, particularly in light of the particular importance that the freedom to manifest religion has compared with other activities in society. and then indeed, as Chris was saying, then looking at whether there were steps that a religious group could take that would enable the same public health policy objective to be achieved, but with a less intrusive impact on what is a critical and fundamental right in our society.
So as we talk about expert witnesses, are you able to share, obviously not names because you're still getting everything worked out, but what type of expert witnesses are we talking about?
So we are going to be needing to work with epidemiologists, and it's also likely to involve a bit of an interplay between related disciplines, because of just the sheer mechanics involved in transmission of viruses, but then also you've got to be thinking about the mechanics involved in certain public places, for example. I mean, you've got every sort of nuance from, it's one thing for a church to meet in a hall, but what if it's meeting in an outdoor tent? So there's quite a few variables that come to play when we're looking at the ways in which a church or another religious group can manage and basically play its part responsibly in achieving the public health objective, but without the state unnecessarily restricting a religious group's legitimate and proper right to manifest their religion.
What about on the like theology front, church history front, stuff like that?
Yeah, we do see value in spending a bit of time establishing that as well, in terms of just tracing the history of how is it that these rights have come to be recognised as such fundamental rights in a country like New Zealand, and there's a history that lies behind that, and we would say that there've been some dead ends over the years, and there have been laws in place in countries which haven't given adequate recognition, for example, to freedom of religion, and we can look back in history and see the negative effects that had on groups in society. And so we do think it is important to trace some of that history as well, as a part of emphasising just why these are recognised as fundamental human rights.
Yeah, it's very easy for us to forget, as the lucky benefactors of living in society which enjoys these sorts of liberties on a day-to-day basis, and we can lose sight of the fact that those rights are built on the blood of centuries of wars, and so setting some context so that we don't lose, particularly when we're engaging in a proportionality exercise. Again, we're not talking about the right for the gym membership here. We're talking about the right to do something that's fundamental to being human.
Yeah, that's helpful. So just thinking about that, there was a case in Scotland which we've made reference to occasionally. How similar are we to that? Maybe do you want to talk about what happened there briefly and what we can learn from that, and maybe the benefits that might come from this case?
Yeah, so there was a decision in the context of the Scottish Church on rules that were made by the government there that were going to impact on the ability of the church to meet, and there are certainly similarities with the same sorts of questions that we would be asking here. There in that case, the Scottish legal system is not identical to the New Zealand legal system, and because of the particular history there and the relationship between England and Scotland, there are some very specific references to the Scottish Church and the fact that the English Crown would not impose itself on the Scottish Church, and you can understand those in the history of that country. But when you look at the case, that history was important, but equally important was the sorts of issues that Alex has been talking about. The fact that while, yes, the civil state does need to act in response to a public health crisis, the manner in which they respond needs to be appropriate and needs to appropriately take into account and give weight to other considerations like the freedom to manifest religion. And so those are the sorts of issues that were decisive in that case and led to the court saying that actually there has been overreach by the government in this case, and there needs to be further review of the decision making because it did not give adequate weight to the importance of essentially the freedom to manifest religion in that context.
Okay, that's really helpful. So the other question then is around the place of Christian concern in all of this. We've talked about them a few times in webinars and stuff like that. Who are they? Are they involved with what you guys are doing?
Yeah, so we have had some interactions with, so Christian concern, we certainly have had interactions with their legal team, and that's been very helpful in terms of understanding that case that you referred to in Scotland. And some of the expert evidence that they've been able to use in the applications that they've made, and what impact that has had in Scotland and England. And so my understanding is that they are very willing to continue to support and to review and to bring their experience to bear on as we work through the arguments that need to be presented in the courts here. And I do think that will be a helpful resource for us as well.
Awesome. So maybe last question, because we don't want to go on too long. We've all got lots of stuff to do. It's Christmas. Time frame and costings and stuff like that. Obviously, Lord willing, one day COVID's not going to be a controlling factor any longer, so we can't be here in 10 years' time. What, spitballing? Where are we going?
I can see, Chris, you're going to give me that one. Yeah, look, it's tough. A lot of it's going to turn on how quickly expert evidence can be assembled, and that because this is it's quite a fact intense analysis that has to be taken, that I envisage that will take some months in terms of working with experts to get that over the line. And obviously you can imagine movable feast pandemic, getting experts who are able to give, who are suitably qualified to give the evidence, who are also busy at work, also advising everything from, corporations to the state. Chocker. But that is the critical next step. So that will take a few months. That will be going alongside that. It's going to be preparing what we would call a statement of claim to commence a proceeding in the High Court. And then once that gets off, it's timetabling with the courts a little bit up in the air. This case raises a unique number of questions of significant public interest, and we'd want to have it heard promptly. But that said, there are competing demands on the court's availability. And likewise, once the Crown is served with proceedings, the Crown is entitled to an opportunity to assemble its own experts and gear up for trial. This is the downside of doing a full trial issue to test the substance. It is a lengthy process rather than a judicial review, which you can generally get in quite promptly. But that's the price you pay to have the real proportionality question, which is so far the unheard big question of public interest that I think there'll be a large interest in having heard.
Yeah, so there's a cost in the sense of time, but the benefit is we really get to flesh out the issue a whole lot more, don't we?
That's exactly right. This is the way to have properly ventilated publicly, the overreach question. Are some of the measures either irrational in terms of not lining up with other measures which might allow for more freedoms in another activity, but actually have a greater risk profile associated with them? Or is this a case where the Crown has unnecessarily limited freedom of religion when they ought to have allowed liberties or allowed alternative ways for risks to be managed? This is how that question can finally be heard.
Yeah, okay, that's super helpful. So obviously there's a cost of time. There's also a cost of money. I'm not going to ask you guys to tell us how much it's going to cost, but the reality is trials are quite expensive. And by the time you've done all of the research and everything, we're talking probably 6+ figures, which means obviously for you supporters out there, we'd really love for you to get involved. You can go through to our website at freetobechurch.nz, because we're not a profit organization, so we're not streaming income into this. This is just a group effort to try and argue for a really, really important principle, which is the right, as Alex has said, really to be human beings and to worship our great God and King. And so I would encourage all of you out there who are watching this to come and get involved with us. Hey, go buy a t-shirt, you wear it around, tell people what it's all about. We'll have to get our lawyers some fancy t-shirts so they can turn up to these things with the t-shirt on. Have you guys got any last comments before we sign off?
I think I'd just say it's been really good to work through this process with you. These are the sorts of questions that, from our perspective, are important, and they're also very, very interesting questions. Yeah, so it's work that we can really sink our teeth into, knowing that it's important. These are important questions to ask and answer. So it's great to be involved.
Yeah, and just add, yeah, the public interest in the question. I think yeah, it is really cool to see this this issue being litigated, because it is an important one. We are in sort of uncharted territories with you know, some of the measures that have been taken, the scale of measures that have been taken by the Crown in response to the current pandemic, and it's really important that we don't lose sight of what we can lose if we go too far, and if we don't let cool heads prevail. And this is a chance to really have some of those heard in a good forum. So very excited to be part of it.
Yeah, it's awesome. I think it's raised a really important point, which is that sense that this is a new thing for New Zealand, even in our legal history, in comparison to the likes of Scotland, where they had previous cases to point back to, and they had fought previous freedom issues and church issues and religion issues, and they had done it with sometimes with their own blood, sealing covenants with their own blood to stand against kings and stuff like this. We haven't had to go through that. In a sense, we as a nation are living off those freedoms that have been purchased over there, whereas now it's being forced upon us. And so in one sense, we could say we're now taking up those same age-old battles again and fighting for human liberties to be what God has called us and made us to be. So it's really an exciting process to be a part of. It's not where I had imagined myself being 2 years ago, sitting in a legal court case and doing all this sort of stuff. So it's super exciting for us as well. But thank you so much for both of your time. I know you're both very busy men. If anyone wants to find where they are, go check out Parry Field Services down in Christchurch. You can Google it. I've heard they've got a long caseload, so I wouldn't go there expecting instant representation, but go check them out and offer them your support nonetheless. And I just mention again, go through to freetobechurch.nz, check out our website, see how you can get involved. And thanks so much for joining us again. Have a most blessed Christmas, and we'll see you out the other side when we start up our webinars again. God bless.